Mr. Darden, Ms. Lewis. The jury is not present. Counsel, earlier this morning, court directed the defense to provide the court and the prosecution counsel a copy of the audio tape of an interview of witness Rosa Lopez, and the court has received a microcassette tape, which I'm going to mark Court's Exhibit next in order, Court's Exhibit 4, and both sides have been provided with a standard cassette copy of this interview. The record should also reflect that moments ago, counsel for both sides and the court in chambers listened to the tape recording of this particular interview. All right, any comment before we proceed with the direct examination of Rosa Lopez on the 1335 conditional examination?
I think the court wanted to query if this found regarding any notes or court wanted to query regarding any notes to be made.
All right, is Mr. Pavlik outside? All right, Mr. Kardashian, would you ask him to join us, please? All right, Mr. Pavlik was again before the court. Mr. Pavlik, you're reminded you're still under oath. Mr. Pavlik, you can just stand right there at the... All right, Mr. Pavlik, yesterday afternoon you advised the court that there was that you tape recorded the first statement, which was July, and you indicated that there were notes with regards to this. What is the status of those notes?
I believe that I indicated that I would check and see whether or not I have any notes, not only pertaining to the issue at hand, but other notes. Whenever I took a statement and reduced it to a memo, I would destroy the other notes that I would take at the scene, over the phone, or in person.
So you've examined your office and your residence, and you have no rough notes with regards to any of the statements that you've taken with regard to this case?
That is correct, sir. Anything and everything that I had, I would fax to various attorneys, and I do not have any notes pertaining to any of the interviews.
All right, thank you, Mr. Pavlik.
Did the court inquire when those notes were destroyed, Your Honor?
Mr. Pavlik, when were those notes destroyed?
They would have been destroyed on the same day that I put out the memo.
Did the court please inquire if it was his habit and custom always to destroy notes as soon as the memo was completed, that why he represented the court yesterday that he thought he had notes?
Mr. Pavlik?
I have saved one note from an interview that I conducted with Mr. Ernesto Rivas and Scott Matsuda, and the only reason that I saved those notes, the original notes, is because I had some streets, addresses, position of police vehicles that were present on Bundy on June 13, 1994.
And those are the only notes that you kept?
Those are the only notes that I kept.
All right.
Did the court also inquire why it was that Mr. Pavlik did not remember what his habit and custom was yesterday? And now he remembers?
There is a discrepancy, Mr. Pavlik. Can you explain that?
I believe that if you look at my testimony yesterday, that I was not only referring to this particular instance involving Rosa Lopez, but old notes. And I wanted to make sure that I had the opportunity to review the file that I had to make sure that there are no notes. I did so in good faith, and I did not find any.
All right. Thank you, Mr. Pavlik.
Could you ask one other question? You asked him whether or not he told anybody at all about this tape.
It's irrelevant.
Well, Mr. Pavlik, when did you first tell any counsel for the defense that this tape was in existence?
When I saw the testimony of Mr. Carl Douglas yesterday, it was obvious to me that I did not inform him of the tape, nor did I inform any of the other attorneys. That was the only time that I was involved in any tape recording, taking a statement that was tape recorded. I immediately completed a report in regards to the interview. I submitted my memo to the attorneys, and I put the tape along with 200 or 300 other tapes that I had, most of them, if not all of them, provided by the prosecution.
Perhaps the court can inquire whether counsel ever asked Mr. Pavlik if he had tapes or notes.
Did you hear the question, Mr. Pavlik?
Yes, I did, sir. I don't specifically recall being asked about a tape. I had been informed and asked regarding the statements and notes that I kept or that I did in this particular investigation. My response was that I have always submitted my memos in a timely manner and that I didn't have anything other than what I submitted.
Then his statement to the court today is that no one ever asked him if he had any tapes.
Is that correct?
I said I don't recall. I am not saying that I was not asked that. I just do not recall, Your Honor.
All right, Ms. Clark, at this point, I think we'll visit the further discovery issues at a later time, as I suggested. All right, thank you, Mr. Pavlik.
Thank you.
Can we just ask, the court to ask Mr. Pavlik one more question, please?
Which is?
Does he have any notes on the computer that were put on the computer, and where is the rest of the interview of Rosa Lopez?
Do you understand the question?
No, I do not understand the question.
Do you have any of these interviews currently held within any memory function of any computer?
No, Your Honor, I do not.
All right.
With regard to Court's Exhibit 4, the tape that the court just marked, would the court inquire of Mr. Pavlik if that is the original cassette tape or is it a copy?
That is the original cassette tape from the interview that I conducted on July 29th, 1994.
All right. Now, you indicated that there are a number of tape recordings that you turned over just recently. You said the majority of which were prosecution provided originally by the prosecution, correct?
I said majority, if not all. Let me qualify that. I believe all of those tapes are tapes that we received as part of discovery disclosure from the prosecution.
So as far as you know, this is the only tape recording that you have in your possession that concerns any of the witnesses in this case?
This is the only tape recording that I have in my possession, sir, pertaining to any of the witnesses.
All right.
There's still the issue of the August 18 interview with Rosa Lopez, for which we obviously have no tape. Would the court inquire of Mr. Pavlik if he taped that interview, or was it in fact a second interview, or was it some redaction of an earlier interview?
Yes. Mr. Pavlik, did you tape record it?
The only
Are there
reason,
any
Your
notes?
Honor, I tape recorded Ms. Lopez in the first interview is because it was a one-on-one. I did not have a partner with me, and that is the reason why I tape recorded. At the second interview, if you would look at the statement or the memo, Mr. John McNally was present with me, and there was no need for me to tape record her.
All right. All right, thank you, Mr. Pavlik.
Thank you.
All right, Ms. Clark? Certainly.
Yes, Your Honor. The court has heard the tape and has heard the nature of the interview conducted. I have never heard anything like that. I have never heard a witness basically coached and told what to say through every bend and turn. Ms. Lopez gave very little input into that interview. Basically, it's an interview of Mr. Pavlik.
And Ms. Hamburger, would you and your client step out? I just noticed that you're back there in the back row. Thank you. Ms. Clark.
Thank you, Your Honor. There are a number of inconsistencies in that taped interview. Not the least of which is the fact that Sylvia, who is mentioned in the written statement of July 29th, is never mentioned in the actual interview that we have all listened to. Furthermore, the fact that there's a conversation that Ms. Lopez alludes to, having overheard at 10 o'clock between the defendant and some other person, that never appeared in her direct testimony. That's just two of many glaring inconsistencies, even though the direct testimony has gone far past the point of 10 o'clock now. And I'll be very interested to hear if Mr. Cochran now goes back to that point and tries to clear all that up. But nevertheless, we need to have this tape transcribed and examined, because we are now we're put in the posture by the defense arrogance, by their contempt for the court's authority and the court's order. We are put in the posture now of having a substantial body of impeachment to do that we must do with Rosa Lopez, that we must confront her with on this conditional examination, and we have to be prepared for it, because the defense has assured us that she will be gone. I've assured the court that she will be gone only if the defense wants her to be gone. Nevertheless, after I think we conclude cross-examination, they will conclude they want her to be gone. We therefore need to prepare for cross-examination, and we cannot effectively cross-examine her to the extent that is required so that the jury will get the full measure of her lack of credibility unless we are given the opportunity to prepare, the opportunity that the defense has contemptuously refused to allow us. I find this unbelievable, what I have seen. And to hear this tape was just, I'm speechless. I'm speechless to think that I'm speechless. I know, that tells you something. I've never seen anything like this. You know, I mean, she was handed a script, and Mr. Pavlik got on the tape and spoke almost nonstop for 15 to 20 minutes, getting her to affirm, yes, 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 yes. No on very minor, inconsequential matters, and I might add, all in English. During no time did she indicate she couldn't understand anything. At no time did she tell him to slow down or explain anything. She corrected him on minor matters of no significance, but therefore indicating that she understood very well what he had to say to her in English, and he spoke rapidly.
Ms. Clark, whether or not a witness feels more comfortable in their native language or English when they actually testify here in court under these rather trying circumstances is a factor that is of no consequence at this point. The question is, now that you have the tape, you've heard it once up in your office, you've heard it once with the court, here in chambers with opposing counsel. The tape is approximately 12 or 15 minutes in length. I don't know that you need an exact word-for-word transcript for 770 purposes. How much time do you need to prepare to review this and to prepare your notes and be able to confront Ms. Lopez with these items on cross-examination?
In order to adequately confront and cross-examine Ms. Lopez, we need to confront her with each and every leading question that she was asked. And as the court heard, there's a tape full of them. We need to be able to confront her with each and every one of those. So those need to be transcribed in order to confront her adequately. What we're talking about here is the people's right to confront and cross-examine that's being denied by the defense misconduct. So we need a chance to prepare for this, and so we do need a transcript of this in order to adequately confront her and let her answer for us what her real thought was. Let's not forget also that there were notes taken of this interview, notes that would have been very impeaching, I am sure, notes that probably preceded this interview, that had to do with what she really had to say before she was coached into saying what the defense wanted to hear. And now Mr. Pavlik, who yesterday told the court that he had notes of her interview, comes to court today and has the nerve to tell this court that he has a habit and custom of destroying all notes, a habit and custom that he conveniently didn't mention until this morning. There is very little credibility to Mr. Pavlik's assertions, and so we don't have the additional material we should have.
Let's refocus on where we are. We are in the midst of direct examination during a conditional examination. You have now been given a tape recording, which is the companion of the report that you have from the July 29th statement.
But it's not a companion because it is
No.
so different.
No,
from-
Ms. Clark, it's a companion because it's the same date. I'm not
Okay.
editorializing
Okay.
or forming an opinion. I'm just saying that the two go together. So you
Well-
have both items.
Well,
All right.
the report,
No, no,
let
no.
me put it this way, Your
No.
Honor.
No, no,
The
Ms.
July
Clark, please.
29th
Ms.
report
Clark,
says the July
Ms. Clark,
29th, but
Ms. Clark, please. It's a very simple question. How much time do you need to prepare and review this tape to proceed with your cross-examination?
well, Mr. Cochran's indicated that he's got a few minutes left on direct, right?
Correct.
So he's almost done.
Correct.
That means we're confronting the issue of our cross-examination right away.
Correct. But I assume that this tape and this particular statement is not the sole basis of your cross-examination.
No, but it's substantial, especially the inconsistencies between the written statement and the tape, and the inconsistencies between those two and the third statement on August 18th, and the inconsistencies between those three items and her testimony as given in court yesterday, and what will be the balance of whatever she gives today. So there's, yes, the tape plays a very focal part in all of that, Your Honor. We have now added a body of impeachment evidence, and we need to get it transcribed so we can confront her properly with it. For 770 purposes. And so we need a stenographer. We're going to need the afternoon to do that. I can appreciate the court's concern in the time factor, but don't look at us, Your Honor. You know, we didn't put the court in this position.
Oh,
we
Ms. Clark,
didn't.
believe me, I'm not putting the onus on you at this point. I'm just asking you a very simple question. How much time do you need? Knowing that I've got a sequestered jury that was brought to court yesterday and spent their whole day here and got to go home.
I'm mindful of that, Your Honor. Had the defense not denied us the opportunity to get the discovery
No, I
the court
understand that.
ordered,
Okay. Well, the longer we stand here talking about it, the longer it'll be before we accomplish all this. What I'm going to do is I'm going to order all parties return. I'm sorry. Sure. Mr. Cochran, I'm sorry. Forgot to ask the other side. Mr. Cochran.
Just briefly, Your Honor, with regard to the record should reflect, and without editorializing and getting into it, the tape was turned over by Mr. Pavlik. They had the tape this morning by 9:30. It's a 12-minute tape. They've heard, we had from 9:30 to about 11:15. They didn't do anything with it. Whatever time they need, Your Honor, it seems to me...
Well, the difficulty has been in getting it copied is what the
Well,
difficulty is.
but they were able to listen to the tape, Your Honor. The tape is very, very simple and to the point. Obviously, they don't like the contents of the tape. This tape is an actual tape of the conversation. The memo that was submitted to them for the 29th and the 18th are memos that were sent to Bob Shapiro. So whatever they need to do, Your Honor, we're ready to proceed and go on without all the editorializing. The tape will speak for itself. As to whether this witness is consistent. We think she's entirely consistent. We think that the fact that, as you pointed out, the interview was conducted in English and she speaks Spanish as a primary tongue, that'll go perhaps to the weight. But the point I wanted to make was that all of this floor showing for the cameras and all these allegations, Your Honor, I want to remind the court of one thing without wasting your time. When the thing came up about Scott Kennedy's video, and we needed it right during the trial, and they'd had it since June. We didn't go running, crying to you, saying, Judge, they had this June, hold them, do all these bad things to them. What we did was say, we want that tape. I set about to get it. They came and produced it after I'd gotten it from Mr. Scott Kennedy. We proceeded with the evidence, continued with this trial. We want to go on with the trial, Judge. That's one side wants to go on with the trial. One side always wants to delay and have a stop, and they're always crying and complaining. Now, they're entitled to this, and they've got it. You've had public under oath, and that's the situation. None of us knew about this tape, and that's the situation. We're going to deal with the other discovery issues, I think, tomorrow afternoon. I would like to try to complete my direct examination, and I'd like to have them proceed with their cross, however long it's going to take, Your Honor. That's all we're asking to do. We have the lunch hour to try to let them listen to the tape again and again. It's only 12 minutes or so, Your Honor. You've heard it. We can proceed, it seems to me. They've got all the direct examination. It's not going to cause a problem. They're not going to transcribe the tape. So we got all the direct examination from yesterday. We've got the direct examination. They've got the 2 reports from the 29th and the 18th. And then they've got the tape, which can, of course, be transcribed by the time they get to that, Your Honor. We just like to be able to proceed if at all possible.
All right. Thank you. All right, counsel, I'm going to direct all parties to return here at 2 o'clock. Ms. Clark, I'd like you to make your best efforts to go over the tape. I don't think you need a word-for-word transcript to proceed for 770 purposes. I think what you can do is listen to the tape, take down what the answer is, just write down what the answers are, and the ones that you find are inconsistent. But let's see what you can do between now and 2 o'clock. And in the meantime, I assume that you're going to have one of your staff members one of your stenographers attempt to make a transcript, correct?
We'll do our best, Your Honor. I mean, that's difficult, but it's not, because it's not that the answers are simple. They're yes and no. Actually, they're all yes. So we need to transcribe the questions.
No, I understand, but I'm asking you to do your best because I want to proceed this afternoon, if at all possible.
We will do our best.
All right. We'll stand in recess 2 o'clock. Thank you, counsel. My apologies for the delay. I was just putting the finishing touches on the court's copy of the transcript of the tape. I said I was just putting the finishing touches on the court's transcription of the tape. All right. What's our progress, Ms. Clark?
I would like to indicate to the court that over the noon hour, as soon as we sent the tape over to be transcribed, I listened to an additional copy of it. And there was more material in the tape than I realized even in the first 2 listenings. And I want to indicate to the court that I was very angry earlier this morning, but I meant no disrespect to the court. I hope the court understands that my ire is directed towards the defense only, and I meant
No, I never
offense.
took your umbrage as directed towards me, certainly.
No, certainly not. And I just wanted to make absolutely sure that if there was any misunderstanding there, I wanted to clear that up. But upon reviewing the statements...
In fact, before we proceed any further, let me give to Mr. Darden, would you approach, and Mr. Shapiro, let me give you a transcript of the tape recording that I prepared over the lunch hour.
Our transcript should be prepared in half an hour as well, so we will have lots of transcripts. But
I think you'll like mine.
you think we'll like it? I'm sure we will. I wanted to point out to the court that in addition to this tape itself, which now the internal inconsistencies, as well as the inconsistencies with each statement, as well as the inconsistencies with her direct testimony, and the inconsistencies with other witnesses who will testify in this case, are numerous, are glaring, and are of major significance to her testimony and her credibility. And so we find ourselves basically placed behind the 8 ball by the machinations of the defense and unable to proceed with effective cross-examination this afternoon. As the court is aware, having been a trial attorney for quite some time, when you have this number of statements by a key witness, it is important to track each and every inconsistency, both logical and literal, in order to, in effect, create a flow chart so that the confrontation with the inconsistencies can be effective and clear. And because the defense has put us in this position, we are now being essentially rushed into a cross-examination that is going to be half as effective as it should have been had they complied with the law.
In other words, you mean you feel you've been sandbagged again?
Well, we have. I don't feel it. We clearly have. And by this third time, the tactic of delay is clearly to gain advantage, and there can be no doubt of it being anything like inadvertence. So I would like to offer the court this. As a sanction, because I know we won't address that actually until tomorrow, but this sanction could be actually adopted by the court today. As a sanction, the people ask the court to terminate the conditional examination. because on the very thinnest of records, the court generously granted the defense request to have this conditional examination pursuant to Penal Code Section 1335. The defense has not only abused the generosity that the court has given it, but it has shown contempt for the direct order of the court concerning discovery matters. Not once, but 3 times now. And these are not trivial matters. These are not matters of form. This is not a question of a couple weeks too late. This is not a question of impeachment on a trivial or peripheral matter. This is key impeachment evidence on a key defense witness deliberately withheld for 8 months and denied being in the possession of the defense until we required the investigator to testify under oath, whose testimony, I might add, under oath, as the court has seen, is suspiciously inconsistent on important key points. Because of the egregiousness of these violations that go to the very heart of the defense case, the people are asking the court to terminate the conditional examination and to consider that if the people had engaged in such gross misconduct even once, what would the court have done? The court would seriously consider, I'm sure, the sanction of preclusion of the witness's testimony at all. And the court would be well justified in doing that. In this particular case, the people do not request that sanction because we feel that we would be prejudiced by that as well. The people want the jury to hear from Rosa Lopez, especially with the wealth of rebuttal material that we have. But I think the court should seriously consider terminating its generous offer to the defense of a conditional examination and require the witness to testify in order as all others in the presence of the jury in the defense case where she belongs.
Ms. Clark, let me ask you this then. Since you raised the possibility, you suggest that the prosecution wants Ms. Lopez to testify before the jury, and that you have a wealth of impeachment evidence available to you, then shouldn't we then proceed with her in front of the jury?
That is exactly the point. We need time. We need time to organize and collate everything.
Then I misunderstood when you say we have a wealth of impeachment. I thought that meant that you had analyzed that, had evaluated, and were prepared to go forward with it.
Well, no, Your Honor, and the court raises an excellent point. It's not enough to simply read a statement of a witness that will impeach the defense witness. One has to assimilate it, one has to determine its significance and what are the key points, and winnow the wheat from the chaff, so to speak. You can't just read a report and then be prepared to use it against a witness in cross-examination, as the court knows well. Cross-examination requires very careful strategy and tactical considerations that preclude a mere reading of a report and its use on cross-examination. And especially with the number of inconsistent statements this witness has, we have a great deal of work to do to impeach her. In essence, all we're really asking for is the very minimum sanction or the minimum grant of a continuance, which is the general posture we're in when a discovery violation has occurred. Now, this is a very blatant and egregious, I think the most egregious I've ever seen in my practice, violation of the law by a defense attorney. And although we could ask for witness preclusion, we haven't asked for that, and we will not ask for that. But we do ask that the court terminate. Lopez is here. Your Honor, could we ask Ms. Lopez to wait outside?
Yes, I'm sorry. I thought she had already stepped out once before.
She did, she came back in.
All right. Ms. Clark?
Thank you. We are not asking for the preclusion. What we are asking for is that that the conditional examination be terminated and that she be called in the defense case if and when they decide to call her, at which point we will have had the time to prepare for her testimony. Exactly the same kind of time that the defense demanded with respect to some very trivial witnesses. They demanded 6 weeks to investigate and prepare for those witnesses. All we are asking is that the witness be placed back into the defense case where it belongs, in front of the jury, which will give us the time to assimilate and organize a cross-examination that will be effective and will protect the rights of the people to a fair trial. I think that the court has seen an abuse of its generosity, an abuse of its patience, and an abuse of the integrity it afforded to the defense. It is no longer justified, their misconduct has become so egregious that I think that the court has to now review its past generosity with the defense. At this point in time, the court is aware of all of the contradictions concerning this witness's availability and her willingness to come to court. And I think that the control that the defense has over her is manifest. If for no other reason, the leading nature of the statements given by the witness in the interview that was basically nothing more than a coaching session by Mr. Pavlik indicates the degree of control they have over this witness. She will appear when they want her to. She doesn't want to go back to Salvador. And it's very, very clear that if she is placed back into the defense case, there will be no risk suffered. The only way Mr. Lopez will not appear is if the defense desires not to have her appear. The people want to see her appear, but in the appropriate time. I would indicate to the court that just on listening to the tape today, and realize, Your Honor, that we have tripled the number of statements this witness gave in 24 hours. And the court is asking us to be prepared to cross-examine with what is going to amount to a tripling of the cross-examination of this witness, not to mention the significance that has now been brought to bear on previous witnesses that we've spoken to that had no significance before. Such as the Sylvia issue. This is a glaring one. We had a tip concerning Ms. Lopez from someone named Sylvia. When we went to speak to her, we had no idea of the significance of that witness because we were not given the July 29th statement. We had no idea that Rosa Lopez was claiming to have been with that witness and that witness would corroborate her observation of the Bronco at 8:30, which is a significant portion of her testimony. Only yesterday did we find out that they are one and the same and that there were allegations made concerning what Sylvia would testify to, which are false and provably false. So that is the problem with withholding of discovery. Now we have information, and there are witnesses that are engendered by the late discovery that have to be interviewed. Statements have to be generated, and they have to be collated and placed in the appropriate place in the cross-examination, which I assure the court will be lengthy. We need the time to adequately prepare for cross-examination that we have been deprived of by the defense. And the defense getting up to urge the court to cut off our time in the manner that they have done this morning is reprehensible because it is their misconduct that has put us in this position. We have to be able to effectively cross-examine in order to give the jury the truth. And what the defense is trying to do is curtail the search for the truth, is to cut off the jury's knowledge of this witness and to give them half a loaf so that all they can see is the side the defense wants to present and not to see the side that basically negates everything she says. As we all know, I mean, you can hear one side, and basically the one side we're hearing is Mr. Pavlik talking, and then you hear what this witness really has to say, and it's shocking. But this is a shocking truth that the jury needs to hear and will not hear effectively if the people are denied the right to prepare their cross-examination in a cohesive manner and present it in the most effective manner possible. We're talking about nothing less important here than the people's right to a fair trial and to an effective and intelligent search for the truth, instead of the obscuring nature and distorting nature of the truth that has been given to this jury by the defense, and which the defense desires to propound further via the testimony of Rosa Lopez and the curtailment of the people's cross-examination.
How much time are you asking for to prepare?
We are asking to present cross-examination on Friday. Assuming the court denies the request to terminate the conditional examination.
Well, I'm just curious as to how long you think you need to prepare.
I mean, that's a minimum. That's rushing it.
Today being the 28th. Okay. All right, any other comments, Ms. Clark?
May I have a moment?
Certainly.
No, Your Honor, thank you.
All right. Mr. Carcon?
Good afternoon, Your Honor.
Good afternoon.
Your Honor, in this instance, it is very interesting to hear Ms. Clark again use all of these terms, and she talks about truth and all that sort of thing. Your Honor, yesterday she stood before you as an officer of this court and indicated to the court that there was a significant difference in the July 29th statement, which she told you that there was no mention that the Bronco had been at the curb at 8:30 and still in the morning. She specifically said that. Absolutely is what she said, Your Honor, and I want to read something. Ms. Lopez stated that the last time she heard O.J. talking was at approximately 11 o'clock hours. She's adamant that from the moment she first observed the Bronco at approximately 8:30 hours until the following day, the Bronco was not moved. Now, in her haste to castigate yesterday, exactly what she said. She said there was the major difference between
Clark, if you would, please don't interrupt, counsel.
the major difference between the August 18th statement and the July 29th statement was the fact she hadn't mentioned it, saying that was going to be some great impeachment.
Well,
I point this out.
Mr. Cochran, let me focus you on what concerns me, and forgive me for interrupting you, but the problem we have, though, is we started the proceedings yesterday with Mr. Douglas telling me that there were no notes and no tape recordings of any of these statements.
That's correct, Your Honor.
That statement was echoed by yourself to this court when you said there are no notes and no tape recording. We find out at the conclusion of yesterday there may be notes and there certainly is a tape recording. So the reason we're here and having this delay is because of the late disclosure of this tape recording. So any differences or subtleties between the two statements or the written statements are interesting. Whether or not they're as significant as Ms. Clark said, I don't know. The reason we're in this difficulty, though, is because of this belated disclosure of this tape recording. That's why we have the problem and the delay.
Yes, and may I address that, Your Honor?
Please.
The point I was trying to make, and I appreciate the court's indulgence, but it's very difficult to have somebody stand up and make these bald-faced accusations that are absolutely wrong, and everybody knows they're wrong. So I felt at least compelled, at least for my client, to address that. But I will focus as the court has asked me to do in that regard. Your Honor, when Mr. Douglas stood up yesterday and indicated to this court, as an officer of this court, that there was no tape recording as far as he knew, he was being absolutely honest, and neither did I know. Your Honor, if we knew about the tape recording, we would have absolutely had it present. If we knew about the other report, we are the ones, if the court pleases, who brought to Your Honor's attention yesterday morning that the statement that I was working from, the July 29th statement, was different from the August 18th statement. As I've indicated, that this was a chore that Mr. Douglas inherited after the first of this year. When we brought that to Your Honor's attention, he said we had to make disclosure. We did that. When Mr. Pavlik came down and said he had discovered this tape, we said, obviously, tell the court that. We did not know that. As he told you this morning under oath, he had not told us that.
Well, let me tell you what concerns me about Mr. Pavlik. When I first asked him, are there any tape recordings or notes, he said these are the only two statements. Then at Ms. Clark's urging and with some reluctance by the court, I put him under oath and I got a different answer.
I was here, and my interpretation was this, Your Honor. He indicated these are the only two statements, but then Your Honor asked him a different question. Your Honor asked him when he was under oath,
Well,
are there any, let me complete, Your Honor. I
Sure.
think the
No,
indication
go
was,
ahead.
are there any tape recordings? If you'll look at that, I think that's my recollection. And he said, yes, there is. And we were just as shocked as you were at that point. I think that was the point that he indicated. I think if you look at that, that's my recollection of it. Did you ask him some question about any other
An
statements?
imprecise question by the court, a great failing of mine.
Well, I'd like to, can we look at it, Your Honor? Because I haven't looked at that. I think that,
Court's question was, all right, are you aware of any statements that have been made or any reports or any notes regarding this witness, Rosa Lopez, other than the two statements that have been turned over? Mr. Pavlik, other than the two statements, no. And then Ms. Clark asked me to place him under oath. Blah, blah, blah. Then I asked him directly, do you have any tape recordings of any statements? And then Mr. Pavlik, I tape recorded the first statement, which was the July statement.
that's what he said. That was my total recollection. That's exactly what you'd ask him, what you did. Now, you can defer different things with
Well,
regard to that.
it was not in the spirit of what I asked him.
Well, Your Honor, I'm not standing up here now to address what Mr. Pavlik did. We all saw and heard what he said. We were surprised. Now, you can imagine that I wasn't particularly pleased either with hearing Mr. Pavlik had a tape statement that I had never heard, that this witness had never ever seen or heard.
All right,
I wasn't
so-
particularly happy about that, Your
So,
Honor.
Mr. Cochran, where we are right now is we're in the middle of a 1335
Yes.
direct examination by yourself with the prosecution saying because of this late disclosure, we need additional time to prepare for cross-examination. Do you find that to be an unreasonable position by the people?
Yes, I do, and that's I'd like to address.
And why
that.
is that?
Absolutely. First of all, we have very experienced lawyers on the other side. Your Honor, they have known about the original statement since September 1st, when Sarah Kaplan and Jerry Ullman turned over all the documents. They've known about Rosa Lopez since that time. For instance, they talk about this clue that led them to Sylvia. Ms. Lopez, we'd indicated that to the court. We never received anything about this clue. And basically, Your Honor, they've known about this. And to show you the power of the prosecution, and to talk about their efforts at intimidation, they have the silent, in a conditional examination, they have her employers sitting here in court yesterday. Now, what does that say to people all across America if you want to be fair about something? They can't be called in a conditional examination. Why do you think they were here? Then at the end of the day, Mr. Darden says, Your Honor, I want to have a witness ordered back during the conditional examination of Rosa Lopez. They then bring in this Sylvia. So in one day, they have all of the witnesses here. And then they would stand here and tell you...
My interpretation was that they were going to say, do you know this person?
That's fine, Your Honor.
Did you say this, anything like this to this person? Having been in that chair before, I understand what's going on.
No, I've been in that chair also, Your Honor, but I think that there may be two interpretations for people who've been in that chair.
I find that to be a plausible guess as to why they were here.
It certainly was, but let me think with you a minute as one who's been in that chair also at the same time Your Honor was. Remember...
No, you were supervising me in that chair.
Well, I didn't want to say that. I was going to say that, Your Honor. Your Honor, with regard to that, if you please... You
did an excellent job, Mr. Cochran.
Thank you, Your Honor.
You're welcome.
But with regard to that, Your Honor, in that office, you know these witnesses aren't just sitting up there all day. Sylvia's not up there all day by herself, not being interviewed by the investigators and what's happening. What I'm pointing out to you, if the court deems that they need some time, these are experienced lawyers. Mr. Darden had a book full of information to try and cross-examine Ms. Lopez. All we're saying is we want to go ahead. Judge, they talk out of both sides of their mouth every day. On Friday evening, they said to you, let's go before the jury. Then they change that for whatever reason. Then when they come in Monday morning, they have a motion to say, well, we want a conditional exam. Now, Ms. Clark stands before you and says, we really want her before the jury. But they'll never really call her because we've got all this great cross-examination. That's what they always say, Judge. Throughout their entire case, from the time they had this rush to judgment, all they do is talk. We want them to present the evidence. And if the court feels that these lawyers who are experienced counsel need some time for cross-examination, then so be it. But it seems to me when Mr. Darden started on Friday, Your Honor, spent the better part of the afternoon on insignificant issues with Ms. Lopez, who then, and the court rules that she's a witness who is going back to El Salvador, and then we come back here Monday, and instead of her going before the juries, we all thought it was going to happen when we left here Friday at 6:30 or 7, we then reverse fields. We come back, and now we start our conditional examination. The court got that done. Then now, because of the fact of the tape and everything, they cannot proceed until Friday. You know, that is just unheard of in a case where we have 21 jurors, and not to mention, not only the jurors, we have Rosa Lopez, Judge, and let me just focus on her for a moment. It seems to me that sometimes my worthy adversaries are totally insulated from what happens out in the world. There are a lot of people who are watching this case, and we have to try to do what is right. And Rosa Lopez is innocent of any wrongdoing, if at all. And to have her maligned by the prosecution for their own purposes, I think is outrageous. Many people believe she's a very, very credible witness. But it doesn't matter what Marcia Clark thinks. Doesn't matter what Chris Darden thinks. Doesn't matter what Sherry Lewis thinks. In the final analysis, it's what those 12 people think over there. And that's where they're going to get their big surprise. When people send in flowers for Rosa Lopez, offer her jobs, send her money in, that's because they understand and they have seen her testimony and observed her. When Ms. Clark stands here and talks about her being untruthful, she is absolutely wrong. Whether you look at the statement, Your Honor, that Pavlik sends to Shapiro on the 29th, where she talks about the Bronco being there from 8:30 till the next morning. Where you look at the statement of August 18th, she talks about the Bronco being there from the 8:30 until the next morning, and talking to Furman thereafter. Where you look at the tape where they talk about the Bronco being there until the next morning. Judge, they have a problem. And the reason why they are going through all these machinations, they're not fooling anybody, is because this is a problem with them. And I should tell you also that because of the conduct, of the way they conduct themselves toward witnesses, there are a number of other witnesses out there, Judge, who know that Bronco was there, who are afraid to come forward. A number of other witnesses who up and down Rockingham, as we're sitting here right now, who know that Bronco was there, whose employers will not let them come forward and testify, some of whom are undocumented. And it is a travesty, because we're faced with that situation, Your Honor, in the face of a man who we believe has been wrongfully accused. And so if there is vehement...
Wait. Counsel, please. Mr. Cochran.
So if there's vehemence on both sides, Your Honor, you can fully understand it. But back to the focal point is this. Your Honor, could you ask them, may I complete my statement? I try not to interrupt
Please.
them. Thank you, Your Honor.
Mr. Darden, please. Mr. Cochran.
Thank you. The point I was trying to make, Your Honor, was we want to conduct and complete this conditional examination. Somewhere along the way, as I asked the court to consider the jurors, to consider Rosa Lopez, who was supposed to leave for El Salvador, was it last night? The reservations were moved. She's got to go back to the other state first. And Judge, you know, she is the one who had promised you. She does not want to be here. She's not asking to be here. She wonders, why? Because I saw something. Do I have to be drugged through this? And my name sullied by these people who have nothing else to do but talk. And so I think that's really unfair, Your Honor. And I just think that somebody should speak up for Rosa Lopez and certainly for O.J. Simpson, who's the one on trial here. And that's why we entrust the fairness to Your Honor. If they're entitled to some time, you know the competence of these lawyers for the prosecution. Your Honor, they are ready to proceed with their prosecution. I spoke to Mr. Darden before Ms. Clark came down, and he said they were typing up the transcript. You've already done the transcript while they're talking about it. There is a transcript. How much more do they want from this transcript? All they got to do is play the tape. Let's all listen to this tape, since they think it's so impeaching. Let's listen to the tape and see what it does for it. Let's play it for the jury if they're so worried about it. I give them an offer right now. Let's play it for the jury. I'm saying let's put Rosa Lopez up there. Let's complete this examination. What they want to do, Judge, by bringing the Salingers here, by bringing Sylvia here, by trying to prolong this, they want her to run away. You made a finding that she wants to leave, and she does. And if you talk to her now, and I'm going to ask you, before you make a decision, finally, to talk to her lawyer. Mr. Jones is not here, but Ms. Hamburger is here. Talk to her lawyer about her present state of mind. She definitely figures into this. And factor in the competence of these lawyers and the fact they're already ready. They've known about this witness since August 18th. And then to come and tell you, today is Tuesday, Judge, February 28th, and to tell you they need until March 3rd is just absolutely beyond belief. And you talk about credibility. It's the same kind of credibility that had Ms. Clark stand up yesterday and said the July 29th statement didn't talk about the Bronco being there overnight. That's in her dreams. It's there every place, every time, and Furman is there every place and every time, and they know that Furman came to see her the next day. So what are they going to do about that? It's like the other witnesses they want to avoid. They don't want to deal with it. So with the court, before you make a final decision, at least talk to Ms. Hamburger with regard to somebody other than myself should speak for Ms. Rosa Lopez. And you've been fair about that, and I'd ask you to do that again. And perhaps Ms. Lopez also.
All right, let me hear from Ms. Clark, and then I'll hear from Ms. Hamburger. All right, Ms. Clark, would you focus your comments on how much time is reasonably necessary to evaluate this transcript, the tape, and then add that into your cross-examination mix? Because that's really the issue I need to address.
And it really is. I'm sorry? Yeah, we're not just talking about a statement and a taped transcript. We are talking about the witnesses whose testimony becomes relevant and important as a result of that, about which this witness has to be cross-examined, with which this witness has to be confronted. We're talking about the testimony of the Salingers. We're talking about the testimony of Sylvia. We're talking about the direct testimony already of Rosa, which is inconsistent with each of the statements she's given and the taped transcript that we have, as well as numerous other witnesses. This is not a little thing. This is a big thing. And I'm sensitive to the issues of witness inconvenience. I deal with it every day. We all do as prosecutors. This is something that Your Honor is very familiar with. Prosecutors have to deal with constantly. And Rosa Lopez is living better right now than she may ever have in her life. And so, and counsel knows it's true. He knows very well it's true. She's not in any way, shape, or form being inconvenienced. And for him to say it's outrageous for us to prepare for cross-examination is the diatribe that this courtroom has been subjected to and this court has been subjected to is nothing short of appalling. All he wants to do is prevent the cross-examination that his witness is going to be subjected to. But we are talking about substantial amounts that has been engendered by this new information, which is, as I've told the court, tripled the cross, because it's brought in a number of other witnesses.
All right,
and
having said that,
I've asked the court for the very least amount of time we can possibly prepare in. I've asked the court for the very minimum amount. You know, I mean, if we were the defense attorneys, we'd be standing here asking the court for 6 weeks, which is what they did. I'm not asking the court for that. I did ask the court to terminate the conditional examination. I think that's an appropriate sanction, and I think that's the appropriate thing to do in light of the witness's inconsistent statements and the behavior that she's exhibited to this court. The court doesn't need to talk to Ms. Hamburger. The court has heard from this witness herself about her state of mind and all of the inconsistent statements and behavior. And when counsel talks about the harassment by the press, this is a witness who's pulling on the skirt of the reporter from Court TV. Oh, I like you.
Well, we've talked about that point already.
Yeah. Okay, I'm sorry, Your Honor. There's nothing about this witness that should give anyone pause about her willingness, her desire, her anxiousness to help the defense in any way possible and say anything she can.
Can you give me any better, other than the generalities that we've talked about, can you give me any other reason why it is you need all the way till Friday to evaluate the transcript of this tape and the tape recording?
First of all, Your Honor, we're only talking 2 days for something that most attorneys would be requesting weeks to do.
No, 3 days.
Well, it's close to that. I think that's very little time. I think it's extraordinarily reasonable of the people, given the nature of the new information that we've got and the impeaching nature of the tape and the statement. And I've been, I think, very specific to the court. We have found inconsistencies, such as defense counsel postures about the fact that she was consistent. No. In the July 29th statement, she states, in the statement, Ms. Lopez stated that at approximately 10:15 to 10:20, she took her dog for a walk, and 5 minutes later she returned to her residence. Ms. Lopez stated that the last time she heard O.J. talking was at approximately 11 o'clock. She is adamant that from the moment she first observed the Bronco at about 8:30 until the following day, the Bronco was not moved. Nowhere in this statement is a specific mention of seeing the Bronco at 10:15. Miraculously, in the August 18th interview, the following statement is made. At approximately 10:15 to 10:20, Ms. Lopez took her dog for a walk, and 5 minutes later she returned to her residence. During this time, Ms. Lopez again observed O.J. Simpson's Bronco to be parked in the same position near the Rockingham gate. I call that a material conflict. Now, what the court heard in listening to the tape is that there was no mention of Sylvia, yet a report purporting to be prepared from the interview of the same date, July 29th, has in it the following paragraph. Shortly after he left, her friend Sylvia came by, and they had a cup of coffee. They spent together approximately 10 to 15 minutes, and Ms. Lopez drove Sylvia to her house a couple of minutes away. When Sylvia observed Simpson's Bronco, she made a comment about the way it was parked. Ms. Lopez stated that O.J. always parks his car that way. Miraculously, in the August 18th statement, that paragraph disappears. We're talking about material, huge inconsistencies that need to be explored with all of the witnesses that pertain to these observations.
But isn't that something that you can explore logistically after this person has completed their direct examination, after you've had the opportunity to ask Ms. Lopez about these things, confronted her with them, so to speak? I mean, the inconsistencies or the apparent inconsistencies are there and are apparent to you, are they not?
Those are. But what about the witnesses whose statements go to these issues? How can I confront her with the witnesses' statements if we haven't collated them and prepared all of them? I mean, Your Honor, you're talking about 2 to 3 days to pull out witnesses and their statements and inconsistencies in between these statements and the tape transcript that would require ordinarily weeks to do.
But cannot Ms. Lopez only be confronted with her inconsistent statements rather than inconsistent statements by other people?
Cannot Ms. Lopez, wouldn't it be more effective, since we are, apparently the defense insists on representing to the court that she won't be here, wouldn't it be effective cross-examination to confront her with the existence of these other witnesses and probe her relationship to them?
You can, but you can't not with their hearsay statements, obviously.
Maybe that's not necessary, but that's what I'm talking about, Your Honor. There are a lot of tactical decisions to be made. There's a lot of preparation that goes into this.
All right, let's assume that I smile favorably on some of your requests for a continuance. What are we going to do in the meantime? I would assume that we could complete at least the direct examination today of Rosa Lopez. Is that correct, Mr. Cochran? Are you prepared to complete that? let's assume that we can complete the direct. What do you propose we do tomorrow and Thursday?
Your Honor, I don't think that the people should be in the position of having to propose anything, given the fact that it's the defense misconduct that put us in this position.
No, I was about to invite you to say, well, perhaps we ought to conclude the cross-examination of Detective Lang.
But how can we be in two places at one time? Well,
I mean, we've got, according to the LA Times, 43 people in the DA's office working full-time on this case.
How many of them are the lead prosecutors in the case? There's only two. We're the ones that are going to be involved. We are the ones that
I didn't believe it either.
Yeah. I don't know. I mean, that must... Never mind.
Okay. I mean, seriously, we have to make a choice here. Somebody's got to prepare this. But we have a trial and we have a sequestered jury, so I got to do work with the jury. That's where we are.
But basically, you know, Your Honor, the people are still being punished for defense misconduct. You know, how is this fair? How is that fair? You know, we're the ones put behind the 8 ball by their misconduct, and the court then wants to have our efforts in the preparation of the cross-examination, which have already been cut back to not 10% of what they should have been by their misconduct. I mean, you know, the defense is greed.
So in other words, you're asking for a complete continuance until Friday. Is that what you're asking
That's
for?
correct, Your Honor. That's correct. Or I've offered the court an option that will absolutely put the jury back in this courtroom ready to go tomorrow, and that is to terminate the conditional examination, which is exactly, you know, exactly what I think should happen here. It's what they deserve. It will not curtail their ability to present the defense. The witness will be here, and we will have the opportunity to prepare for cross-examination. It answers all problems.
All right. Thank you. Thank you.
Just a few last words, if I might. The people never can accept the court's ruling. You've ruled this the conditional examination. They couldn't accept that then. They still don't want to accept it now. Every opportunity to try to change that is it seems to me to be totally inappropriate, and I would ask the court to not do that. That seems to be inappropriate. It seems also, Your Honor, that this is what we're talking about here, Your Honor, so that we're perfectly clear. We're talking about a 12-minute tape.
15.
Well, 15 minutes, it seems more like 12, but the first part is admonitions, and I'm not threatening you or whatever. 50, you've done the tape, so 15-minute tape. Your Honor, how long does it take a lawyer, 15 minutes, a tape that tracks a July 29th statement to prepare that? Whether they got 43 people working up there or 15 or 20, there are plenty and ample people to do this cross-examination. They're already prepared on it. This is the only thing added, it's 15 minutes of tape. And so do what you think is reasonable, but I would ask you before you make your decision to not make it based upon the machinations of client and this unreasonable estimate. It seems to me, if the court would listen to Ms. Hamburger and Ms. Lopez, she is the real party in interest in this, and I would ask you once again to do that. And I think if you look at this statement, counsel tries to go through the statement and pick out certain portions of it or whatever. I think what she has to point out, this is Pavlik's statement. So she's having a real difficult time impeaching Rosa Lopez on Pavlik's statement. She can ask her questions, but she's got to ask Pavlik about what he wrote and after the conversation. That's what it's about, and they seem to forget that, Your Honor. They do not have a statement signed by Rosa Lopez. They have her voice on this tape. They can play the tape, as I've invited them. No foundational problems at all. Play the tape. And so, but would you please listen to Ms. Hamburger and Ms. Lopez before you rule as to what's appropriate, Your Honor?
All right. Thank you, counsel.
Thank you.
All right, Deputy Browning, can I have Ms. Hamburger, please? Ms. Robertson.